Good morning, ladies and gentlemen. Mr. Dunn is not guilty of this charge, and I fully expect that the evidence that you're going to hear from that witness stand, taken together with the law that the court will instruct you on, will show that to you, and that at the end of all of this, that you will return a verdict of not guilty because that's what the evidence has proven to you. It will show that Mr. Dunn acted to defend his life from a real threat or what he perceived to be a real threat at that time and in those circumstances. And it's that time and those circumstances by which his judgment, his perception, and his reaction must be judged. What the evidence will show you is that Mr. Dunn was confronted by an angry young man that was yelling at him, cursing at him, and who he believed brandished a firearm. And fearing for his own life, afraid of losing that life, reacting to that primitive instinct to survive, Mr. Dunn acted to defend his life, and he shot to defend himself. And as soon as it was safe for him to do so, he left that dangerous situation. Now, the court's going to tell you, and you've already heard this to some degree, that you can't use sympathy in looking at the evidence or determining how you're going to weigh it. And we would ask that you be cautious about that particular thing, because invocations to sympathy can come a lot of different ways. It can be a very blatant attempt from the stand to invoke your emotions. It can be in the words used when they point, the state points your attention to the youth of their faces, to the fact that they were smiling. All of those word choices are deliberate. And I ask you to keep that in mind as you evaluate the testimony in this case. And keep in mind, is this something that's going towards proving these charges? Or is this something that's going towards trying to touch my heart? Because that's not what this is about, ladies and gentlemen. It's about objectively weighing and analyzing what you hear from that witness stand and applying the law that the court will give you to that information. It would be wrong, legally and morally, to allow emotion to cloud that judgment as you sit through this evidence. Because let's face it, unfortunately, while this ended in the death, tragically, of Jordan Davis, there is nothing that says that a 17-year-old man cannot be a threat. And size doesn't matter when you have a gun. Now, you will not hear us dispute that a shooting occurred. At no point during this case will you hear the defense or anybody on the defense side dispute that a shooting occurred and that that shooting took the life of Jordan Davis. That's important to keep in mind as you go through the evidence in this case as well. Because the other thing that you have to evaluate as you hear and see the things from that witness stand are, what is this really proving to me? Is this quantity over quality? If you were shown 15 pictures of a gun when we have said that a gun was used by Mr. Dunn in order to commit the shooting, does that prove anything to you about what caused that gun to be fired? That's what I mean when I say you need to keep these questions in mind as you evaluate this evidence. 15 photographs introduced into evidence of casings or guns or ballistics evidence, all of which go to show that a shooting occurred, all of which are things that we are not disputing, and none of which proves anything about who the aggressor was and whether or not Mr. Dunn acted to defend his life in a moment of real fear. And you have to keep an open mind about all of these questions until you've heard all of the evidence. Keep in mind, the law that the court will give you is the presumption of innocence and burden of proof, and proof that rises to the level of beyond a reasonable doubt. And listen through cross-examination for the inconsistencies between the witnesses, both within their own testimony and amongst the testimony of all the witnesses together. We talked a little bit about in jury selection this idea that there can be a single event that different people perceive differently. And that's important because you'll hear from some witnesses who perceived an event one way, and you may hear from other witnesses who perceived an event in a different way. And your job is going to be to look at those perceptions from both sides, and then make a decision based on the facts and circumstances that were in place then, not in the safe confines of this courtroom, what actually happened that day, if you can. The evidence I expect you to hear is that Jordan Davis was riding around in a red Durango with his friends, Leland Brunson, Tevin Thompson, and Tommy Storms. That they pulled up to a Gate gas station after having gone out to the town center before that, hanging out and trying to find girls. But that when they pulled up to that Gate gas station en route to another location, they were playing extraordinarily loud music. Tommy Storms left that car, he went inside, and in the meantime, Mr. Dunn pulls up next to them. I expect that the evidence will show you that Mr. Dunn asked to have that music turned down. You are not going to hear from any witness. I do not expect you to hear from any witness that Mr. Dunn ever raised his voice, that he ever yelled at anybody, that he ever pounded the steering wheel or gestured wildly with his hands or cursed anyone or used any racial terms or derogatory terms of any kind. You are not going to hear anything like that about Mr. Dunn's behavior. Mr. Dunn, who lives outside of Jacksonville, was in town for a happy event. He just finished celebrating his son's wedding and had just left it with his fiancée, Rhonda Rao. He's in a happy mood, a happy place, just seeing his son get married. No idea of what was about to happen next to him in his life. You'll hear that one of the guys in that car, Tevin Thompson, upon getting that request from Mr. Dunn, parked next to them, actually turned the music down. He was asked for common courtesy in a public place to turn down that extraordinarily loud music, and he responded to it. And if it had ended there, we wouldn't be here. But it didn't end there, ladies and gentlemen. And the reason it didn't end there is not because of Mr. Dunn, it was because of Jordan Davis's actions that night. Tevin Thompson turns down the music, but Jordan Davis got angry, and you'll hear that from the other people in the car with him. It was a little thing, just to turn down the music, but for some reason he got really angry about it. And the evidence will show that Mr. Dunn, not having yelled, not having threatened, not having cussed, not even having raised his voice, but still, Mr. Davis, in response to that simple request, still got angry. And he escalated things. He's the one that escalated things. That's what the evidence is going to show. That he took everything up a notch when he told his friend angrily to turn it back up. He says to his friend, F that N-word, and I expect you'll hear it, the actual statement from the stand. That's what he says to Tevin Thompson. He's sitting behind Tevin Thompson in the back seat on the passenger side so that Tevin Thompson, front seat, what you'll see here is that Jordan Davis is in the back seat, and Mr. Dunn's car was parked to their side of the car. And after Tevin Thompson complies with the request, Jordan Davis says, F that N-word, turn it back up, and Tevin Thompson does. He took it up a notch when he began yelling at Mr. Dunn, including cursing, raising his voice. He took it up another notch when he started cursing at him. He took it up another notch when he threatened him, saying, I'm going to effing kill you. And again, he didn't use the F word. I should kill you right now. That's the testimony that you'll hear from the stand that came out of Jordan Davis's mouth. He took it up another notch when he brandished a shotgun or something that looked very much like one. And he took it up another notch when he opened that car door to come towards Michael Dunn. And that's when Mr. Dunn said, this isn't stopping. This just keeps going up and up. And afraid for his life, having never left his car, he reached for the gun, and he got the gun that he was legally entitled to have with him, that he had owned for years and had never had to use before in defense of himself, and fired to protect his life. The testimony will say to you that he fired 3 shots at where he perceived that threat to be. He fired 3 shots at the passenger door where Jordan Davis was. Now, you'll see that there are other bullet holes in that Durango, but the evidence will say to you, will not be controverted, is that those other shots that came to the front passenger side of the Durango occurred not because Mr. Dunn changed his aim and was now firing at everybody in the car, but instead because the Durango began reversing. So Mr. Dunn always, when he fires at where he perceives the threat to be, where he saw that barrel, which is coming from Jordan Davis's area of the car, from Jordan Davis's window. So he fires those 3 shots at where the threat was. Then the Durango starts reversing, and he's still firing at where the threat is, but because the Durango's moving, those shots then come farther up the car. Once the Durango and then thus the threat left the area, Mr. Dunn and his fiancée immediately left. He was in shock, didn't know what to do. And yes, you will hear a video recording, an audio recording, and you'll hear those shots. And what you will hear is that there was nothing slow or methodical about those shots. There was no time to reflect, no time to think, that they all came one on top of the other in response to the threat to his life. And the other thing to keep in mind as you listen to all the evidences is that already we've talked about this incident for far longer than it took for it to actually happen. And we're going to be talking about it for the next several days. But the evidence will show you that this took place in a matter of minutes, within a couple of minutes, where the threat was being escalated by Jordan Davis, and then within seconds was all the time the actual shooting took. So, and keep that in mind in terms of judging the reaction. Mr. Dunn had only seconds to react to that threat and try to protect his life. Mr. Dunn, not being from Jacksonville, didn't know anyone, did want to contact the authorities and wanted to do it through a friend. He does drive home, and first thing in the morning, he goes to a neighbor who is himself in law enforcement, tells him what has happened, and tells him that he wants to contact the police. And he sits there in his friend's home while that friend calls the police. He sits there until the police arrive. He sits there while they order him out of the house with his hands up. He complies with every request, including to kneel when he comes out. He talks to the police in spite of the fact that they tell him he doesn't have to, that it is his constitutional right not to make a statement, that he has a constitutional right to remain silent, that anything he says can be used against him. And in spite of being warned that by the police, he says, I do want to tell you what happened. This is what happened. And he tells them that he was threatened and that he acted to defend himself. And he believed he'd acted lawfully and then was shocked to be arrested for these charges. And you will hear from at least 2 expert witnesses in discussing the tragedy of this young man's loss. You will hear first from Dr. Simons, who was at the time that this incident occurred with the medical examiner's office here in Jacksonville. It was her job at that time to perform autopsies on deceased individuals and work closely with the state attorney's office on these kinds of cases. You will see that Dr. Simons is offered as an expert in the area of forensic pathology and perhaps in a couple of other areas as well. What you will not hear is the defense challenging Dr. Simons on any testimony that she gives regarding wound path or cause of death, because those certainly are within her areas of expertise. What you will also hear, though, from the witness stands is that we will challenge when she starts talking about bullet trajectories and body positions. You should listen carefully to what credentials she has on those issues, or rather the lack thereof. And keep that in mind while evaluating her testimony. You'll also hear from a witness by the name of Michael Knox. Michael Knox is a former law enforcement officer with the Jacksonville Sheriff's Office of many, many, many years. He is a man who worked as a crime scene detective with the Jacksonville Sheriff's Office, who taught other crime scene detectives how to do and evaluate and process these types of crime scenes, major crime scenes, that he taught for years at their police academy to other officers, that he is extraordinarily well trained on issues such as bullet trajectory, the use of specific techniques to determine the path of a bullet, not through a body, that's Dr. Simons' area, but the path of a bullet through the air and through objects. And you will hear Mr. Knox say that the Durango's rear passenger door was open at the time that those 3 shots were fired. Therefore, thereby corroborating what Mr. Dunn told the police about what happened that day. And that, ladies and gentlemen, is what brings us here. For you, good ladies and gentlemen, to hear the evidence, to apply the law as the court gives it to you, and impassionately, objectively, bring justice by finding Mr. Dunn not guilty. Thank you, Your Honor.
Thank you, Ms. Hanania. State can call their first witness.
May I have the podium, Your Honor?
Yes, ma'am.
And the state will call Stephen Smith.
Stephen Smith, please. If you have a lapel mic on, please put that on. I would prefer that, and then you're fine. Unless you're going to stay right there at the podium. Mr. Smith, if you'll come forward to the front for me, please, sir.